Well, good evening. From Beth Israel, the West Temple, on Triscuit Road in Cleveland, Ohio. Welcome back. Tonight's town hall talks about a difficult subject, but a subject that we all need to know more about and to understand and always be prepared to handle. We have two honored guests tonight, Alexandria Ruden from the Legal Aid Society of Cleveland and the Honorable Joe Hochheiser, who sits on the bench in our family court system deciding cases of domestic violence. Good evening to you both.
Good evening.
Alexandria, could you tell us what the Legal Aid Society means to the city of Cleveland and the people who live here?
Well, I would like to start by talking about its mission, which is to secure justice, resolve fundamental problems for those who are low income and vulnerable. And we do this by providing high-quality legal assistance and working for systemic solutions. And what we do is we represent low-income people in 5 counties: Lake, Cuyahoga, Lorraine, Ashtabula, and Cuyahoga. And we are the gatekeepers between what shouldn't be and what is and what could be. Our job is we deal with evictions, we deal with family problems, we deal with subsidies, we deal with public benefit issues, we deal with bankruptcy, we deal with immigration, other consumer problems, and I'm sure I'm missing some. But we look holistically and begin to address the problems facing low-income people in the city of Cleveland.
And your specific role?
And my specific role is I'm a senior attorney, and my focus is family practice, but we focus on domestic violence, and we represent survivors of domestic violence and divorce in protection orders, custody cases, child support, most of the family law type cases.
And Your Honor, sitting on the bench on this type of highly emotional matter, how long have you been doing that, sir?
So, first of all, thank you for having myself here. It's a very important topic, as Alex has just said. And I kind of want to, if you allow me, just this little introduction. Typically speaking, we refer to victims or survivors of domestic violence as she or female. Around 80% of my cases that come before me are female petitioners, people who are asking for protection. 20% are male. So obviously it's not all one gender, but we typically refer to as she, so people shouldn't be offended thinking that it's always females. Also, this is a sensitive topic, and if people feel uncomfortable with this topic, I want to kind of talk about that because people should feel uncomfortable about this topic, but this topic needs to be spoken about. It occurs in all communities. It occurs in many insular communities, whether that is the insular Jewish community, Catholic community, Muslim community. This happens in all communities, and there is this taboo around domestic violence that I thank you for having us to talk about this topic, because we really need to pull the sheets off of that taboo. I always say that a community that chooses perception over protection is when they try to sweep things under the rug. So we really have to focus on the protection of the victims and their survivors we have in our community. Now, to go back to your question, I work at the pleasure of the 5 elected judges in domestic relations court. The docket that I work for has 3 dedicated magistrates and 8 dedicated staff members, including a full-time victim advocate who work exclusively on domestic violence cases. So generally, people know domestic relations court covers divorces or people who have been married. Our court handles anyone who has been married, who is married, any parties who have lived together in the past 5 years, and any party that share a child in common, regardless of whether they were ever married or not. So the clientele that we come into our court is really from a wide range of social economic class, religious backgrounds, and really stretches the entire Cuyahoga County.
And can I just add one thing?
Yes.
I think people know about domestic violence. If you ask people if they know about it, they're going to say yes, but not as it relates to them. If it happens to them, they look at it as this is not domestic violence. And that's what makes it hard, having to explain to somebody that what happened to you was violence. You did not consent to it. It is not your fault. So again, they hear it, they see it, they'll hear something, you'll talk about it, but what they don't do is they don't then they project it outwards. They don't look at themselves and see that it could happen to them.
So while I was listening to you, the first simple next question is, in very simplistic terms, I'm guessing the two of you are very busy at what you both do.
Absolutely. I mean, other than our representation of clients, we try to do a lot of advocacy work because part of it is systemic solutions. So you look at the laws, you look at amicus briefs that one files in the area of domestic violence. So we have made significant progress. And again, I became a lawyer when the domestic violence law passed in 1979. I was a law student, became a lawyer in 1980. So I have followed the trajectory of Ohio's domestic violence law since its inception.
And it's still growing. 2 years ago, we've now started including dating violence within the civil protection order. So as Alex was saying, how she was there in the beginning, she could tell you stories about them creating the statutes. But even now, we are expanding it. Dating violence is also considered domestic violence according to the civil docket. So through the hard work and advocacy of people like Alex and her organization, we are making a lot of inroads, but there's still a long way to go.
So I'm very aware of the process, and we'll talk about the process on the civil side. In a criminal domestic violence, differentiating from civil, it is the police department that files the charge. It is the police department who hears the information, takes the report, gets the witness statements, takes the photos, presents it either to me or right to the court. And the victim and the defendant are parties, but it's directed by the state of Ohio.
The victim is just a witness for the state.
Exactly. And it's in the work that you do, both of you, it requires that victim to knock on the door and come in and see you and say, can you help me?
I think the difference is for civil protection order, it's victim generated.
Yes.
The victim has to put out the request.
Yes.
The victim has the right to dismiss that case at any point. If the victim doesn't go forward, at some point it will be dismissed. On the other hand, in a criminal case, depending on the nature of police investigation and whether prosecutors believe they can present the case without the victim, they may even begin to do that without the victim. It was sort of victimless prosecution. I remember in the 90s, it was like treat the victim as if she or he, but that she is dead. You know, you gather evidence as if you have no victim, a speaking victim. And that's how police began to really look at the type of evidence needed separate and apart from that victim.
So let's take what you just mentioned. Your Honor, tell us, laymen in the audience, what it means to have evidence of domestic violence. What do you look for? General overview. What would be evidence of domestic violence to you? Besides, well, I'm going to include, okay, a broken arm. But what if it's not a broken arm? Tell us about that.
So I will tell you statutorily, according to the law,
Good.
It is threat of serious physical harm or actual physical harm or menacing by stalking. I can get into that in a moment. But people have to realize that domestic violence is not necessarily one act. The police get involved when there's one act. When there's one act of breaking someone's arm or one act of a physical assault, the police are going there, they're arresting the offender, and many times it's really out of the party's hands at that point because the prosecutor's bringing
Correct.
that forward. With domestic violence, and the reason why our court has a dedicated docket is the realization that domestic violence is a pattern of conduct of coercion and control, power and control over one party over the other. So if you view domestic violence like that, many times people come before me, and we spoke about this the other day. A woman comes before me and says, you know what, I came to the breakfast table and there was a bullet on the table. So this is Alex's story. So
Yeah.
I'm going to let her.
He's taking my story.
So, but
I want to say that.
okay, so I won't say it. So basically, in my court, I get to view the totality of the circumstance. I'm not only looking at one act, but I'm looking at a course of conduct of power and control, and whether that is manipulation, whether that is physical harm, or whether that is intentionally inflicting mental distress upon another. If there's a course of conduct where he's constantly causing someone mental distress of such a level that that person would need to seek professional help, then that person is a victim of domestic violence. And the police are awesome in Cuyahoga County and across the state of Ohio. But they only look at singular events. When they come out to a crime and the woman said that he threw something at me, and they're like, well, that's not really a big deal. But what they don't take into account is the months upon months of this type of behavior, or the threats. And finally, he crossed that line, or this is a straw that broke the camel's back. I'm able to not only look at that straw, but I'm able to look at the whole pile of hay.
And I just
Tell us the story about the bullet.
But before I tell you about the bullet, we measure domestic violence by the physical injury, which means anything else is normalized. And we need to really look at reframing the issue, to look at this pattern, to look at coercive controlling behavior, to look more broadly, noting that the visible injury is only one piece of it. And frankly, if I hit you once, I don't need to hit you again. All I have to do is raise my arm. You know what I've done to you in the past, so I'm afraid. But when I was a newer lawyer, 37 years ago, or 40 years ago, I had a client come in to see me. And she comes in and she's crying. And I said, so tell me about the domestic violence. And she said, he put a bullet on the kitchen table. And I'm like, huh? Domestic violence? He didn't say anything to you, did he? No. But then so I didn't understand. But then I asked her, why are you afraid? Why does him putting a bullet on the kitchen table? Because I'm thinking of myself. If my husband put a bullet on the kitchen table, I would say, what happened? You're cleaning your gun in front of the kids. The dog could eat it, the cat could eat it, but I don't worry, my husband's abusive. But what she said to me is several years before, he played Russian roulette with her. Oh. And then it made me think, when you look at this, you must look at context. And that says, if I'm going to present evidence of a threat to Magistrate Hochheiser, I need to tell what the whole history of that violence, because that is how you can tell why that bullet meant something and why that victim is at risk of significant violence in the future.
Many of the cases that come before me, it's a situation where the police will say, we cannot arrest anybody, but go get a protection order. So the police are trained, and everyone could use more training always, but they are trained to know if they can't do anything, hopefully they will point them in the right direction, either to my court or to the Legal Aid Society.
So let's try to walk ourselves through how the process starts and how we get to your courtroom, Your Honor. So let's say, and again, male or female, let's just say it's a male. It doesn't matter. They call your office. They say they were a victim of domestic violence. Are you the only person in your office that can see them?
No, we have several family law attorneys.
Okay.
We have several in Cleveland, and we have one in each of the counties.
Does everybody get a chance to come to see you?
No. We need many more lawyers because family problems are significant. Some people come in requesting protection orders. They are at higher risk, but we have to do an assessment. So they usually go through our intake, and they have to meet two things. they need to be a victim of or a survivor of domestic violence, and they have to meet our financial eligibility requirements. And again, we have to know that we can do something for them, that we're going to make a difference. And then, if we can, we will set them up for an appointment. So all the family law cases that come in saying they want protection orders will come through intake to us, the ones that fit within our guidelines. And then we look at them, and then we call and we see if we can help them and represent them. And then, if we can, we end up preparing papers for, let's say, a protection order. And the Supreme Court of Ohio has promulgated forms. So you have standardized forms to be used around the state, and you fill out the forms. I do it by way of an affidavit. I want to tell the court what the victim has suffered at the hands of their abuser. So I go in with the most recent incident backwards. So tell me what brought you to come, what happened that caused you to need a protection order now? And then I go to the past. And then I end with, why do you believe your life is in danger now? Because the case law has evolved from one act to one act plus danger of future violence. So you look at both of those tiers when you assess a case.
And what happens if the violence has been perpetrated against a minor child?
A parent can go in on behalf of one's minor child. The hardest part about going in on behalf of your child is that if your child is young, your child may have disclosed to you but cannot take the witness stand. How do you get that evidence in? Because anything you say as the mother or the father would be potentially hearsay. So it becomes much more difficult.
So let's say that you meet with the person, you comprehend, you think, you realize this is a case that's appropriate for filing. How does the Cuyahoga County system operate so that you get to his honor?
I don't quite
I mean,
understand.
how do you
Wait,
file
wait.
the paperwork?
It used to be that I would go to the clerk's office, I would file the paperwork, I would take it over to domestic, I would get the name of the judge, I would have the judge or the magistrate hear it, I go back across the street to the Justice Center and file the order, and then my client would get a copy. But now I prepare the paperwork, I bring it to the Domestic Violence Department at the court, they go over the paperwork, they always tell me there's some little thing wrong, and then if I haven't prepared, because over time the Domestic Violence Department has created other forms that will help sheriff's departments, that will help police, that will address respondents' issues. And then, if everything looks good, they file it, they get the judge, and then they look to see who the magistrates are. And the client has always been, up until COVID, with me at court. Since COVID, things are different. And I guess I would let Magistrate Hochheiser
Well, and this
talk
is
a
what I
little bit
wanted you to
about
speak with,
that.
since you're the representative, you're here, your employment's with the court. Tell us what makes Cuyahoga County's divorce court department different than every other county in the entire state.
Through the Violence Against Women's Act, our court, or our domestic violence court, receives a grant, and we are one of 12 mentor courts in the country who exclusively focus only on domestic violence cases. I don't handle divorce cases, I don't handle custody cases. The entire department just focuses is on domestic violence civil protection order, the issuances of them, the modification, and ultimately the termination if it comes to that. And then we also have an opportunity in direct coordination with legal aid is that we get to train. We get to train police departments. We get to train other courts across the country. We had a conference here last year. We had people come from Alaska and hear, of course, Alex speak. But and we get to collaborate and share ideas because we are on the forefront of not only domestic violence but the subcategories of the domestic violence. So that's firearm forfeiture. There's a huge discussion. I don't want to call it a fight. There's a huge discussion about firearms and the relationship that they have with the domestic violence perpetrators. Strangulation. Ohio is one of a few states who, two states who do not have a separate crime of strangulation. So a strangulation and a punch in the arm is considered the same type of crime. And we're one of only 2 states. So, as I said, you've been doing it for a lot longer, but there's still so much more to go. So our courts get to be on the forefront of these topics, and we get to train other courts. I do think it's also important for people, everyone, to realize that in 2019, our court had 701 filings for protection orders. 612 of those were pro se. 612 represented themselves. So legal aid does unbelievable work, but there are only 3 attorneys who do this type of work, and they can't represent anyone. But everyone. But domestic violence happens to everyone in every community. It happens to rich people. It happens to poor people, people who don't qualify for legal aid. But that's why our court is so amazing, because we have a dedicated staff of 8 dedicated people who only do domestic violence cases. So a layman, someone who doesn't know anything about the law, can come down, work with our staff, and fill out that paperwork, and the same day they file that request for a protection order, they are required by law to have a hearing. And if I grant them protection, I could remove the offender from the house. It doesn't matter on ownership. If the perpetrator has a condo under his name and the victim doesn't have any legal right to that condo, I could check a box, and the sheriff's office will remove him from the home. I can get her exclusive possession or custody of children. So that threat that many times perpetrators say, you're never going to see your kids again. I'm going to keep your kids away from you. Legally, I'm able to grant exclusive custody and exclusive possession of a home. So those biggest threats that we hear time and time again, you're going to be homeless if you file this. You're never going to see your kids if you file this. Through the hard work of people like Alex and the Legal Aid Society, we have made such leaps and bounds to offer that immediate protection. So they file that paperwork, and the same day they have their first hearing. And then we get due process, which means we let the offender know what's going on. And within 7 or 10 court days, he is entitled to a hearing before me. So it comes real quick.
And who wrote the grant for the court to get that specific division?
I worked with Judge Palos, who had the vision to see that there was something in this idea.
You deserve the credit.
Well, no.
So
Judge Palos is unbelievable.
Yeah,
I know
she is.
She is
she is watching, so
I've
shout
known
out
her.
to. Yeah, of course.
and
she's
I've known her
watching.
for a long time as well. I'm honored to say that.
Yeah.
So let's talk about the person that comes in to both of your offices and says, today may be February 24th, but on July 9th last year, he gave me a black eye.
And if
What
she-
happened? I mean, does that, I see that in my prosecutorial role. Do you both have that circumstance
That-
where it really is delayed
So
significantly?
it's
Well,
toofold for.
Well, let me
but-
talk
okay,
from
but
the
discuss the-
standpoint.
okay.
What
Go
were you
ahead.
going to say I should discuss?
There's a
what?
difference between that emergency order without due process and that full hearing order, because we're looking at 2 separate things.
But
Go-
I don't think that was his question. I
What
thought
happens when it really did,
when it
really
occurred
happened?
yes, but here's the problem. Because it's a special statutory proceeding, and as Magistrate Hochheiser said, it is an emergency order, it is much harder to get a protection order January 24th for an incident that took place the previous July. The question would be, where is that emergency? Now, there is another way of filing your orders, which is you don't file it as an ex parte. You file it as you would any normal civil action. But most people would not go back 6 months unless there was a criminal case pending and we're waiting till the end of the criminal case to begin the process of the civil protection order. But short of that, or if that victim or survivor were in the hospital for much of that time, but all things being equal, it would be very hard for me to go in and argue on behalf of a client that this is an emergency order today for something that happened long ago. Now, I would ask my client, are there any other incidents? Have there been any threats? Has there been any stalking behavior? Has he committed aggravated trespass, come to the home? Has he committed acts towards the children? If any of those are more recent, then we have much more of the history as well as something that is recent.
So in a criminal case that I'm involved in, my burden of proof is the highest burden there is, beyond a reasonable doubt. So our police officers, they are not set with that burden. I am set with that burden as a prosecutor. It's a pretty steep mountain to climb sometimes. Sometimes the evidence is very evident. What is the burden of proof? Is it different in a civil level, and what is it?
So it's a preponderance of the evidence, and that's the legal term. And essentially what that means is more likely than not. So I say it kind of tongue-in-cheek, but if it was a scale, right over there, 51%. But that burden of proof also goes on my decision-making. I have a lot of discretion on whether I issue a full 5-year order or whether I issue a shorter order. Sometimes it's not, the risk of harm is not so high. Many times people are either going through a custody dispute or a divorce. So I have the discretion of issuing maybe a 2-year order or maybe a 1-year order pending. So it's not either all or nothing. If you meet that burden at 51%, you're not getting a 5-year order with everything. And sometimes every case is different, which is why I absolutely love what I do. Every single case, there's not 2 fact patterns that are alike.
So Alex, when somebody comes in and they report that they're married, that they have children, that they have bills, that maybe she's not working, he is, she's the homeowner, so there's economic dependence, and you hear information that makes you believe a petition is appropriate. When you tell them that he's going to be ordered out of the house, he's not going to see the children, have you observed some persons who will step back and think, oh my gosh, there's ramifications? Not that she's changing the facts, but I didn't understand what would happen if I actually went forward. Have you had that happen?
A lot, and we have to assess, the client and I, do you need a protection order? Understand what happens if you get a protection order.
Yes.
That means he cannot come around you or she cannot come around you. You have to remain separate. He or may not have any parenting time. He may, but he may not. He may be ordered out of the home. He may be ordered to have no contact, and it could last up till 5 years. Now, clearly you can modify it, but depending on where they are, they may not want a protection order because of that. But then we can file a divorce, and we can work with their economic insecurity by helping them get child support, by helping them get custody, by working out a different type of arrangement with the thought that we can always get a protection order if there is new violence.
And I don't want to create everybody thinking that every case ends up with a 5-year order
No.
and a divorce. Are there times, and I'll ask both of you this question, are there times when they start out distraught, overwhelmed, correctly scared, and somehow they find the strength with their spouse to change what's happened and have a good ending to the story?
Well-
do you hear that enough? Well, let's go one at a time. Do you hear that?
Yes.
And do you hear it a lot, or is that really the exception to the rule?
I don't hear it that much, although there are clients that go back with their abusers. There are abusers that feel they can change. Sometimes they can become better. Many of the studies show that batterers interventions programs don't necessarily work. But as we're moving forward, the client gets stronger. And as that client gets stronger, that survivor gets stronger, it may not hold the same fear as it did when they first came in. And through my practice, out of 100% of cases that come in, 50% would dismiss their cases and try
Is that
again.
right?
And of that 50%, at least 25% of those would call me back at a different time. And what we know is that victims of domestic violence, it takes a while to get out of the relationship. And sometimes staying in the relationship is safer for that victim. And they know their abuser better than I do, better than he does, better than you do. So they know what they need.
And Your Honor, when you're up on the bench and you're hearing the information, can you think about what the repercussions are going to be if you enter the order you really want to order? Or do you just look at the fact and say, she needs to be protected?
So I think it's also important to realize that after that initial ex parte hearing, when they come back 7 to 10 days later, they sit down with the case manager. We do not mediate domestic violence cases, but they can enter into a consent agreement, which is an agreement for a protection order. So over half of my cases don't end up going to trial. Half of my cases end up in an agreement that may allow supervised visitation through Safe and Sound, which is an organization that does supervised visitation. Or maybe they will agree on a parenting agreement with a third party exchanging the children. So it is not all going to trial, all or nothing. Half of our cases end up in an agreement, which is awesome. And when there's attorneys on either both sides or one side, it makes it even easier because the attorneys are able to cater an agreement that really works well with an active protection order, taking into the safety of all the parties involved. But to answer your question, Ms. Ruden and myself were driving here today, and we actually we just had a case maybe 2-3 weeks ago where we had a respondent who had very little legal leg to stand on. And Ms. Ruden asked for the case to be thrown out at the earliest possible point because he did not state any law for which he could be granted anything. Even if I would believe everything he said, there wasn't a legal basis for his case. But this guy was so hot behind the collar. He wanted his day in court. He wanted to let the judge or the magistrate know what was on his mind. So that was one where, could I have said, you're done, you haven't presented any facts, goodbye. But I didn't. I let him put on his case. I let him say his piece. And then as soon as the case was over, I issued a decision. So I do take that into account that both parties are here because they want to be heard. And even if someone's wrong, sometimes they need that to get it off their chest. Because if I would have cut him off, if I would have thrown him out of that room, it's possible that the person who would got the end of it would be him violating the order, being upset with this woman for dragging him through this again. So it's very possible. We don't know what's going to happen. So I always try to be fair and impartial to both sides, but I also try to think about what each one is going through. But to answer your question, if there is a risk of domestic violence, my only obligation, I must look through it as a black or white. If there is that domestic violence act and a risk for future violence, I need to issue that protection order, and I rely on domestic relations court or juvenile court to figure out the details in terms of parenting.
Can I just add just
Yes.
one other thing? Many times, if a survivor comes in to see me, they minimize what's happened to them. And they think, oh, I just want a divorce. I don't want anything. I just want out. Everything's fine. And I do, like, in my brain, this danger assessment to see. And when I see high risk, weapons, jealousy, first violence while you were pregnant, strangulation, firearms, I get really scared. And sometimes I even have to tell my clients, I know you don't seem afraid, but I really am afraid for you. But because it's victim driven, once again, it is that survivor who has to make that decision. Sometimes that survivor will talk to an advocate. Sometimes I say, let's do nothing for a week or two. Talk to an advocate so you can figure out where you are. You need safety planning. You need to begin to address that. Sometimes they need healing, and they need to, they needed to talk to somebody, but then they needed to step away and figure out what they needed.
I'll always remember a case that Barb Joyce and I had Mrs. Brown, who had been assaulted, and she had a young child. And the first meeting, she said, "This is all my fault. It really didn't happen. It's not a big deal. The police acted unruly," to give every excuse. And I knew that she was telling me something that wasn't true. And Barb Joyce, who was the best victims advocate, we all know that, said, "Okay, Mrs. Brown." And after court hearings, Mrs. Brown came around to say, "I just wasn't in the right state of mind 72 hours after being beat up." And by the end of the case, she was a total advocate for her protection. The reason I'm bringing that story up is, do you both see, not quite recantations, we're going to get to recantations, do you both see people who just can't identify their own abuse?
Yes, a lot. And that's why when Magistrate Hochheiser was saying we need to pull back the layers to talk about it more, I think many victims don't see what's happening to them as abuse. And then when they have their abuser telling them, again, "I didn't abuse you," or "You caused this," or "It's because of you I had to hit you," then they really look into themselves and say, "Look what I did. I did something wrong. I provoked it." And they have to get past that. And that's why sometimes the best advice is to say, let's hold off for a bit. Maybe as an advocate to figure out how you can safety plan around what has happened to you. Sometimes they just need to get stronger. Sometimes they are strong. Sometimes they come in and they know what they want and they're ready. And sometimes they'll go in, they'll get the ex parte, and then they'll dismiss it. It's any type of, it's not just one size fits all.
Yes.
It happens in different permutations all the time, and you just have to be aware of it.
Dogs and kids. A woman could be in an abusive relationship for years and years, and if he touches the dog or if he touches the children, they will come in and they will testify for an hour and a half of this one incident of him kicking the dog. And then when you start peeling back that onion, she's been in an abusive relationship, sexually assaulted. None of that is on her mind. He promised he would never touch the kids. He promised he would never hurt the dog. And that will be that straw. So that is why we have a dedicated docket. That's why we have victim advocates who are awesome and attorneys who are great to peel back those layers. So when you present it to me, he kicked the dog, I would like a protection order. Ma'am, that's not enough for a protection order. But he said he would never kick the dog. That's not enough. So and when they're representing themselves, sometimes it's a huge burden on them, because I need to be fair and impartial to both sides, and I could guide each party to ask leading questions, but I can't testify for them.
So that brings up an interesting point, Your Honor. You use the word pro se. The three of us know what that means.
Yeah, I'm sorry.
That means people that come in all by themselves, and they have no more legal knowledge than anybody else, which generally is very little, or what they've heard or they've watched on television. How do you deal with them in comparison to those who have counsel?
So we still need to follow the rules of evidence, the local rules, and the rules of civil procedure. A courtroom is, as we're sitting here in a sanctuary, a courtroom is a holy place. There is something called the decorum of the courtroom. Our old courthouse is beautiful. I know that you have been there. But there is a certain respect that all parties have to give, and the magistrates and judges have to give to the law. Justice can only be if we treat everyone on the same level. If I have two people representing themselves, I will guide them through the trial. I will tell them who goes first, who goes second. When it's their turn to ask questions, I'll tell them that they should ask a question implying an answer or not implying an answer. I say you have to ask open-ended questions, and I give them examples. I will metaphorically hold their hand through a trial, but at the end of the day, especially with people who have mental deficits, I cannot try the case for them. So I can say, well, why don't you tell me about the last incident of abuse? That's really where I have to stop. And they said, well, it happened 2 weeks ago. Is there anything else that you would like the court to know? No. So sometimes my hands are really, really tied, but we have victim advocates who I could actually tell the victim advocates, get this person help. There's organizations to help this person. So we could guide them, but we can't try the case for them.
What will make it easier is the Supreme Court recently adopted their new forms, which take effect April 15th, and the petition for protection order will be significantly changed. They'll ask the statement, when was the last physical incident, you can talk about it, and then it's not a prompt, but they'll say, has there been strangulation? Has he ever choked you? Has he ever threatened you with a gun? Has he ever stalked you? And then you can write out some of those things. So it will make it easier for first the victim to synthesize their thoughts and make it easier for the court to at least say, turning your attention to your statement, you said this happened. That can be asked. But I wanted to go back with children a bit. Does anybody remember Ray Rice? And Ray Rice beat up his girlfriend in the elevator. And
Baltimore Raven.
yes. And after that, there was a blog. And this is what crystallized for me how hard it is to separate from one's significant other. Somebody wrote a blog and said, I stayed so my children could have a father. I left so my children could have a mother. And when those survivors realized that they also could be killed, that's when it suddenly changed for them, and they realized what they needed to do.
So what happens if we have a language barrier for both of you? Do you, on legal aid staff, have someone that you can refer them to if there's a language barrier?
We have Pacific Translation. I can't remember exactly what the name is, but we can talk with them, and
Okay.
then we can hire interpreters to come to court. We have policies on that. Then we can also ask the court, who has to follow federal law, that there should be, as part of access to justice, the availability of interpreters for the court hearings.
I actually had one today. I had an Arabic interpreter. So we have many different cultures here in Northeast Ohio. It is
Yes.
the melting pot. It's always been the melting pot. We've had, probably can count 10 different languages that I've had interpretation services for. Actually, now that it's the pandemic and Zoom actually makes interpretation a little bit easier. There's some great functions within Zoom. Trials or hearings take a little bit longer, but we treat them exactly the same, obviously just having to wait for the interpretation. But a victim should testify in their native language. I don't want that victim trying to figure out what word for this is or what word for that is. I want them to testify in the language that they are most comfortable. Domestic violence is trauma. And Ms. Ruden could talk to hours about trauma. The trauma brain is different. The recollection of the events are different. And if you give that party an extra burden of trying to speak a language that they're not completely comfortable with, it's going to work to their detriment.
And the Supreme Court has recognized that, because many of the domestic violence forms are being and have been translated into many different languages. Not the orders, but the instructions, the petitions. The orders have to be in English because most officers speak English, and because of that, they need to know how to enforce it.
So let's cover a subject that I think is one of the most difficult parts of this. I just got a call today from a victim saying she doesn't want the case to go to trial, that it didn't happen, that the officers made her make up the statement, that, undue influence on herself, she doesn't want it to go forward. There are two parts to that from my perspective. One is a true recantation. I'm sorry, those events didn't happen. And the person, as I mentioned before, that is saying, this can't happen, there's too much, the effect would be too significant. So let's talk about recantations. I'm guessing you both have dealt with them many times. How do you both deal with the issue of, I wasn't kind of telling the truth, really it didn't happen that way. He's not responsible.
So with me, what happens is because it's petitioner driven, because it's user driven, if that victim doesn't appear for that trial day, I have but no other choice to dismiss it for what we call want of prosecution, for not bringing it forward. But oftentimes they either agree on an order or they went to trial and I granted them an order. And now they come in 6 months later after testifying horrific acts and are now saying, we're back together, I would like to terminate the order. So I see recantation kind of on the termination, and I love my job. I get to deny those. The statute gives me 12 elements I need to consider, and as the trier, or as the finder of fact, I'm able to tell that party, I'm sorry, you did not meet your burden to terminate. So I'm going to keep that order in place.
Wow.
And it doesn't happen all the time, but unfortunately, before me on that initiation of an order, creating an order, if they say I don't want to go forward, they don't even have to give me a reason. They can just say, I'm not showing up for trial, and I must dismiss it at that point.
Because they're the applicant.
Exactly. They are their own prosecutor.
Yes.
And that's why it's different from a criminal case. But we know that victims recant for so many reasons. He got to her. He was in jail, but he kept calling her. And when that happens, first he says, hi, I love you, tries to get her back. And then there's this study out of Ohio State. Amy Bonami had written it. And what they researched is the recantation wheel. And basically how it moves from, hi, I'm sorry, to you caused me to do it, to, it's the system's fault. The system caused us to not be together, and we need to be together. And finally, that victim is worn down and then sort of says, well, the only person that really cares about me is my abuser. And that has been shown to be extremely important when you look at recantation. There's also something that I think a few states have, the idea of a recantation defense, when they say, I didn't tell the truth, rather than say, okay, we're going to charge you with perjury. We don't charge you. We do something different. And I think when you look at recantation, especially if there's some visibles, it took place for the most part. So I know for me, if a client comes in to see me and then calls me back and says, I don't want the protection order, which just happened, and it didn't happen, I'll sit down with them and say, I think that it did, but you need to feel comfortable. So you need to address what's going on. And the thing is, if I say I'm there if you need me, when they are ready to accept what happened, they will call back, they will come back.
And I always, even on my termination hearings, so parties come in and they terminate, I always tell the parties that our court is here to serve you. I have had parties, I've had petitioners come in and they've had 2, 3, even 4 times prior, their petition was dismissed because they didn't show up, or they recanted at trial. I never hold that against the party. And even when I terminate, I tell people, this is not going to be a black mark. You're not wasting our time. This is what we do. If you need, I tell both parties, because I'm fair and impartial to both sides, I tell both parties, I said, if you need our services, come back. Because oftentimes, violence, I was a prosecutor for 8 years. When you have that initial recantation, they go through that no one's going to ever believe me again. I already used that card once. They're not going to believe me again, because that's what the respondent or defendant is telling them. So I make it very clear. I don't care how many times you come before me. You're always invited back.
Hence why we have this department, because the magistrates in this department,
Thank you.
especially somebody like you, by knowing that and understanding that, survivors will feel they can use the system. And it's this lack of feeling the community system is going to help them that makes them feel, I don't want to have any part of it. But when a magistrate can say that, when a lawyer can say that to them, they will feel at some point that they can come back, that they will be believed, that they did nothing wrong.
So have there been times, I have observed this in my many years, have there been times when you thought, again, I hate to use the word she's using this for more than one purpose?
Yes.
Yes, he hit her in the shoulder, but there's something else going on here. I can't quite figure out what it is. Ulterior motives? Talk about that, Alex.
Sorry.
Go ahead.
It has happened, but not often. Most survivors don't want to put themselves in that situation. However, there are times where he hit her, I'll use she too, he hit her in the shoulder, but she's not afraid. Well, and she doesn't want any order, she just wants out. Well, I have to really assess that and see, is that something we can do? Because we usually take emergency cases where there is that kind of domestic violence. Sometimes victims, really, it's not the physical, he made a threat, but really, I want the kids. So it can be a custody issue.
Yes.
So do I believe that people have abused protection orders? Absolutely. Does it happen often? No.
So absolutely, it does not happen often out of the 700 cases. And when you see dual filings, this is where our department trains. So you see someone filing for a divorce and filing for a protection order, and that protection order is kicking the respondent out of the house and giving the woman exclusive possession of the children. So there are two ways to look at that. Someone may look at that, be like, she's using it as a play, as a power play. Or the other way to look at it is she has finally got the courage to separate from this man, and she knows him. And she knows those threats of violence is now going to come because she has finally had the power to file that divorce. So are there people who use it? Absolutely. Do we see you have a custody hearing tomorrow and you've been going through a divorce for 1.5 years and now you file a protection order and talk about something that happened 6 months ago? Okay, so there are people. 2 years ago on Christmas Eve, I work on Christmas Eve because everyone else should have the day off. Right. So I work Christmas Eve, and we had this woman come in to file for an emergency protection order for her children because on Christmas Eve, her ex-children, 3 children, go to the father's house. And last year, the son didn't like his Christmas gift, and his father spanked him, possibly with a belt. I don't remember the exact details. I'm like, wow, that's, if you use a weapon or if you leave marks, child abuse and discipline, physical discipline, it's a gray area, unfortunately, here in Ohio. But hitting with a belt, I would normally find that raises to the level of child abuse. I said, well, when was the last time the son went with his father? She's like, 2 weekends ago. I said, but you're telling me what happened last year Christmas. She's like, well, the son didn't want to go there for Christmas because of what happened, but I can't be a custody magistrate. So there are people who try to use it in that manner. Now, if the kid only went over there on Christmas and the last time he went over there he was abused, that may be the basis for a protection order. But the fact that he goes there every other weekend and she's coming in on Christmas Eve, so you can kind of smell those out. Are there people who abuse the system? Yes, but we don't throw away the baby with the bathwater. We are talking about a very small percentage, and because we only do domestic violence cases, we can spot them.
So if the parent has been abused and the children have not been abused, can the children on a protective order?
Yes.
Yes.
They are protected parties. First of all, when you say the children have not been abused, the children witness domestic violence
Okay.
in
That
probably
is domestic violence.
80% of the cases.
Say that again?
And in over 80% of the cases, children witness it. They either see it, they hear it, they are in the house when it happens, or they see the results of it the next morning when their parent wakes up goes in to see them with a black eye. So they know it exists. Therefore, those children should be on the order because it has a detrimental effect on the children. Not all children respond the same way, but it has a detrimental effect. The law has has sort of morphed into, if you want to put a child on as a protected party, there must be some level of abuse towards the child. Most courts are accepting if the child was witnessing the domestic violence. So you at least have to ask, when you put the child on, has that child witnessed it? Yes, and like I said, in almost all the cases they do. And then you ask the client when they go to court, so you've put your child on as a protected party, can you tell the court why? And then they would say, because my child, he was out of the house when it happened, but the next morning I woke up with a black eye and my shoulder was in a sling. So the child knew. So
Witnessing abuse of a parent is domestic violence. If that's not intentional infliction of emotional distress, I'm not really sure what is. Children that come out of abusive households are more likely to be offenders because it scars their brain. It changes their brain to either recognize that violence is okay, or seeing a loved one being abused or in harm afterwards. That is child abuse. So
I'm sorry, do you both see situations where a parent is trying to manipulate a child parent? Have you seen that?
I have seen it, but rarely. I don't, they've debunked parental alienation. And then the question becomes, and it's something that I have to assess, there's a difference between protective parenting and alienating that child from that parent. In fact, many children at some point in time will go to that abusive parent, not because they love him or don't, but because they become them. And then they see their parent, their mother, let's say, as weak. So they want to be with the strong person. But I think the magistrate touched on something really important, the cyclical intergenerational nature of domestic violence, that girls who grow up in homes like that see that men act that way, so they are more likely to become victims, and boys who see their fathers act the way they do, if their fathers are the abusers, can become perpetrators. However, a lot of it depends on the protective factors. A good support system, let's say a teacher, somebody from temple, somebody from church, who takes that child under their wing, that child is more resilient and can overcome many of the deficits. Some children cannot.
And a child who sees a parent doing the right thing and making those hard decisions in terms of a protection order, that is that first step for that child.
So let's talk for a few minutes before we finish about the Jewish community. Have you both had instances where we have, let's say, an Orthodox situation where the mom of, let's say, numerous children is being abused but is not in favor of going forward because of the relationship, because of the community in which they reside? Can either of you, both of you, speak to that?
Well, let me, because I know you have much more experience with that, but I have very few Orthodox Jewish women who come in to see me for divorce or protection orders. I don't know why, whether it's downtown, whether we represent low income, I don't know if there's a stigma, which I do believe anyway within the Jewish community, there's a stigma against involving the system. But we have, at least on the east side, Jewish Family Services.
Yes.
And they have Hebrew House. And they have the
Hebrew shelter house.
Hebrew shelter, Hebrew House, and Hebrew shelter. And what they do is they really do a good job of talking with their clients, educating their clients. And again, since I don't get them, I don't often know what happens to them. Sometimes they will call me and I will take a case. Sometimes they call me for advice. Sometimes they use private attorneys, which seems more palatable for some of those clients.
So, Your Honor, speaking from the Orthodox community, tell us about your experience with this situation.
So I'm not going to generalize any community. I'm going to say insular communities, whether that's the Muslim community or the Orthodox Jewish community. There is this concept of sweeping it under the rug or dealing with it internally. And I think that is dangerous. It's a community that chooses perception over protection, where I started off. I've had several, probably out of 800 cases, probably 10 from the Orthodox community. But I also do training and I also do talks within the Orthodox community. Oftentimes, when a woman goes to the mikvah, she goes every month, the person in charge of the mikvah is trained in domestic violence and has that Hebrew shelter home information. So sometimes that once a month where this woman is without a controlling, manipulative partner, that she's able to have those resources. Smaller communities or insular communities tend to have more resources, so they deal with it without the court system. That's not always a positive, because sometimes they will go to a community leader, and the community leader may say, well, he'll stop drinking, and then he won't abuse you anymore. Domestic violence is not about anger. Domestic violence is not about anger management. It is about power and control, and unless you address those things, but those are the only two communities, the Muslim community and the Orthodox Jewish community, where I had community members in the hallway before a trial. They weren't going to be witnesses. I'm not saying that they were there to intimidate the witnesses, but you had a full hallway of people from the community. So those are the only two. I am part of the Orthodox community. There is so much good that they do. There is a social stigma with domestic violence and using public assistance. Many times, if people are less wealthy, they are used to asking the government for help. They're used to filling out these forms. They're used to waiting in line, and they're used to accepting help from people from the government. There's a pride with people of a certain social economic class that it's I don't want to say beneath them, but there's this hesitation to ask for help from a government agency. I won't use a government lawyer. I won't use a free lawyer. And unfortunately, we see this. Women sometimes, my mother always works. I'm not going to generalize. My wife works. Sometimes you have women who don't work. So the male is the only breadwinner of the home.
Yes.
So there's this additional burden of, if I divorce him or if I get a protection order, he's going to cut me off. So there's definitely those concerns.
I think you said a really important thing, the fact that that many communities deal with it internally. I don't see it with the Muslim community. I get a lot of Muslim clients, but I do see it in the Orthodox Jewish community.
Do we have any questions, Deb?
Is there any difference how elder abuse is handled?
Oh, yeah, Ed, I called Ms. Ruden. I was yelling and screaming at her because our statute covers child abuse. So if we have a parent abusing a child, they can get a protection order for that. It doesn't go the other way around for elderly abuse. If you have an elderly parent, now if it's abuse, direct abuse, but that neglect. So if you have physical violence, I'm going to back up and I'm going to go overtime because I have the microphone. Domestic violence is not only an intimate partner against another intimate partner. It's very important to realize that domestic violence is any blood relative who have lived in the same house. We have many older people, not older, but we have many people in their 60s, 70s, 80s requesting protection order against their grandchildren. Unfortunately, we have had and will have a huge heroin issue in Northeast Ohio. So you children harassing their grandparents and being physically violent with their grandparent, and we're able to give the grandparent protection orders against the grandchildren. It is not just intimate partners, it's anyone who's blood related and lived in the same house. So elderly abuse, if there is physical violence against a elderly loved one from a person who's blood related and who has lived with them any time in the past, we are able to issue a protection order. And there is a huge issue with elderly abuse, but unfortunately, neglect is not always abuse.
Nor is caretaker abuse, just generally. But then you can call the Adult Protective Services and they can get involved. And I think there is a bill pending to really expand that, not in the domestic violence statute, but to address more of the elderly abuse that addresses neglect. But I have had cases, and what I have found interesting in the case law is that threats and physical abuse, clearly, but is emotional abuse domestic violence? And that is interesting. And one could argue under the stalking statute if it causes mental distress. And they have, the appellate courts have allowed victims to come in where they have come in and said that what the perpetrator has done, he hid my medicine, he took away my walker, and the courts have granted protection orders.
Hiding car keys.
And then the appellate court would uphold it, saying that this is mental distress. And what a victim would have to show is a day before that and what has happened since they've been afraid. So it can happen. I wouldn't say it happens all the time, but it does happen.
So we've had a discussion that's moved quite quickly, I believe, over a subject that we needed to discuss. And these are two guests with their amazing knowledge and passion for what's occurred. I thank you both for taking the time. I know you both work all day. You come in here after hours to speak to us in our community, and we greatly appreciate your time and your efforts this evening.
Thank you so much for having us.
Thank you
you very
very
much.
much for having us.